If the New York State Department of Health renders deficiencies as a result of improper medical care that you received in a hospital, can you use those findings of fact or conclusions of law in your medical malpractice case here in the state of New York? Would you like to learn the answer? Come join me. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. The short answer is maybe. The longer answer is also maybe, and here's why. When the Department of Health goes ahead and investigates to determine whether or not the treatment you received at the hospital was appropriate, the standards by which they use are slightly different than what's used in a medical malpractice case. How is it that sometimes we can use certain findings and sometimes we can't? Well, in a jury trial involving medical malpractice in New York, sometimes we can use the investigator's findings of fact because they're the fact finder. They're the ones who are supposed to evaluate and determine what exactly occurred. Now, in a malpractice case in New York, the jury is in fact the fact finder. We have to present testimony and evidence, and the jury is the one who's supposed to determine what exactly the facts show based upon the evidence that we present. Now, the conclusions that the investigators reach, oftentimes we will not be able to use those conclusions at trial. Why not? Because those conclusions may be different. It may be different than the conclusions that our experts reach, that the defense experts reach, that the plaintiff's experts reach. And ultimately, it's for the jury to come to the conclusion as to whether or not we've been able to prove that there were departures from good and accepted care, that the departures were substantial factors in causing or contributing to your injury, and that the injury is significant and permanent. And the reality is that as an attorney representing injured victims, we don't actually have to prove that much. What do we have to prove? We have to show that we're more likely right than wrong, that what occurred to you is actually the truth. And if the jury finds that we are slightly more likely right than wrong, then we're entitled to a verdict in your favor. So that's why in many instances we cannot use the conclusions reached by the Department of Health investigators. However, in some instances we can use the findings of fact to establish what actually occurred during the course of the hospitalization. So why do I share this with you? I share this with you to give you an insight and an understanding into what goes on into the litigation process here in the state of New York. Chances are you have questions and concerns about your own particular matter. Well, what I encourage you to do is pick up the phone and call me. I answer legal questions like yours every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Jerry Oginski here in New York. Thanks so much for watching.